Hello, everybody. My name is Bahar Karbakhsh of the Law Office of Bahar Karbakhsh from Toronto, Canada. I'm an immigration lawyer and mediator, and today I have a very special guest. My dear, please introduce yourself.
Hello, everyone. My name is Demi Guo. I'm a Canadian immigration consultant. I practice in Markham, Toronto, and I was really honored to be here. Thank you for having me.
Thank you so much for being here today, Demi. So, Demi, as an immigration consultant, tell us a little bit about the type of work that you do and the communities that you serve.
Okay. I do regular applications, and I also go further to Immigration Appeal Division for challenge the decision on removal order and sponsorship or residency obligation appeals. I do individual as well as a cooperated immigration as well. The only area I don't practice is judicial review in the federal court level, which all the cases goes to Bahar.
Yes. Thank you so much, Demi. So in terms of your practice areas, you've been kind enough to tell us about that. Tell us about the type of cases that are maybe coming up for you now. We're in end of November 2025. What are the things that you're seeing more of these days?
Okay, since I came out from the regular immigration law firm, I start practice myself, and the majority of my current clients are Chinese backgrounds. And recently, the most challenge case I have are the delay on application decisions. Most of the clients undergo lengthy background check, which caused the delay to up to years. These cases, how we deal with, and we go, which called the right of Mandamus, which is the most challenging case that we have to argue in federal court level. That's what I have the most difficulties these days.
Yes. So basically how long it takes to receive a decision on any type of application that you're putting in. And that's where you and I have done a lot of collaboration, where you will, whether it's your client directly or it's a colleague's client or someone who has reached out to you in Canada or outside Canada, and they've been waiting for a very, very long time for a decision. Usually they've done many follow-ups, sent web forms. Sometimes if they're in Canada, they do other things like go to an MP's office, but none of that has really helped. And so that's when you would reach out to me as a licensed lawyer, where I would go to the federal court for this Mandamus application. And what's really important to reiterate here is that it's not just that the normal illicit processing time has, we've passed that. It's usually, the legal the legal test is that it must be an extensive period of time. And that's 2, 3, 4, 5, 6 plus times the normal processing time. So in a visa situation where, for example, it might list a few months, for residents of China, you've sent me cases where the person has been waiting for over a year, right?
That's right.
And so that's multiple times the normal processing time. Or for a PR application or work permit application, same thing. If the normal processing time was about a year, now we're looking at 2-3 years. And that's the type of case that would be appropriate to kind of take to the federal court and try to challenge, how long it's been.
That's right.
Yeah.
Because these type of the case, usually, especially work permits, and then drag too long, it's directly impact the applicant's career planning.
Yes.
And for the PRs, all like people, especially for those applicants waiting inside of Canada, they couldn't buy a house. Their career is up there, and then they have to constantly renew their work permit. Their families, the whole family plans is up to there. It's really a big impact on my clients.
Yes, of course, because they've put an application with some sort of plan, especially for the work permit. They were able usually to get an employer to want to take them on. And then this Canadian employer is waiting, right? When is this work permit going to be approved? And so there's unfortunately these really lengthy delays that cause lots of problems in their planning in life and all these things. Another topic I wanted to talk to you about, because we're getting more inquiries and files, is about misrepresentation.
Yes.
So tell me a little bit about what you're seeing, and I can also share my thoughts as well.
Sure. These days, I'm seeing misrepresentation cases not only in the federal level. There's also in a provincial level that there are investigators for the documents that based on sometimes it's the documents misrep or sometimes directly information input misrepresentation interviews, all that cost the refusal of the applications. For the federal parts, you get procedure fairness letters, and then if you don't address it properly, or if you're, not hit to the point to argue what caused the misrepresentation,
Yes.
then the consequence is huge, because government punished these misrepresentation applicants in a serious level, not only just ban you for 5 years,
Yes.
but it will be ongoing consequence for you to apply for any other countries immigration applications, or even later on you want to return to Canada for other permanent or temporary visa applications, it will still bring back on the table. Yeah.
Absolutely. So just to kind of reiterate in a more thing term, so if an officer believes that there was either fraudulent document provided or fraudulent information provided in an application, what they must do is provide a procedural fairness letter where they give that applicant a chance to respond to the concerns, and they have to take that very seriously and really do respond with whatever documentation they have, or explain the situation, whether it was a mistake or a misunderstanding or whatever the case might be. But in the event that the officer has reviewed what you've submitted and then they still find you as having committed misrepresentation, what happens is there will be what they call a 5-year bar on being able to enter Canada.
Mhm.
And, that's a huge deal, not only for people's plans of coming to Canada, but also with the countries that Canada shares information with, like the US, like the UK, like Australia, like New Zealand. Any type of application that you may even wish to submit to those countries, something as simple as like a tourist visa to visit one of those places, once it says, a 5-year bar, misrepresentation Canada, unfortunately, they just see that, right? They don't even see really the details of it. And so even if it was like a minor mistake, to have that on your record is a big deal. And it kind of will follow you around. It's kind of, I would say, analogous to when someone gets a criminal conviction, and no matter what you do afterwards, if that's on your record, that kind of follows you, where you go. So in these type of situations, if you believe that there was a mistake, a misunderstanding, whatever the case is, you were working with somebody who submitted information on your behalf that you did not know about, and I know we see and hear about that a lot too, it's really important to not only provide a real robust response to that procedural fairness letter, but in the event that they do find that there's misrepresentation, you really do need to challenge it at the federal court. And that's where, a lawyer comes in, and that's where Demi has sent me files in that regard, where, someone has called her and said, they found a misrep here, and what do I do about it? Right? So I know I've worked with people from the Chinese community with some of these types of issues. And a lot of times what we've been seeing is like people will go work with these kind of ghost consultants, in their own communities, a friend who says, I know how to do it. I'm going to charge you, something. And sometimes it's not a lot, but sometimes it is a lot. And they will put something forward without the person's knowledge a lot of times.
Yeah.
And then they're in these really bad, sticky situations. And then the person needs to explain in a fulsome way at the federal court, because then the applicant has a chance to put forward an affidavit with evidence to explain what it is that has happened here, and try to, undo that kind of wrong that has happened in their case.
Yes, unauthorized representative wouldn't disclose their information on the application, and then usually the applicant themselves are the one being punished for the information that's
Yes.
the unauthorized representative put forward, and then it's called the indirect misrep.
Yes.
It's really hard to explain, and
Yes.
So
this is another point. I know we weren't going to really delve into this, but it's just like as we're talking, it makes me think about the fact that a lot of times people will just go with some ordinary person or quote unquote these ghost consultants who, have no professional regulatory body. You have a professional regulatory body as immigration consultant. Paralegals who can do certain type of work also have the Law Society. Lawyers in Ontario or other provinces have the Law Society of their province. And so we are under their authority. And if something goes wrong, we have to be accountable to that. But when people go and work with just, somebody who says, I do this work, or I can do it for you, or like a friendly assistance, what they don't realize is that a lot of times if you end up in trouble, that comes at a huge cost. Right? Not only financial to try to sometimes undo that wrong, but also the headache, the stress that now, on this immigration file or history, I have this mark, and whether or not we can make that go away is really a question.
Yeah, and also that the misrepresentation could be even like very small as a check box of yes and no.
Yes,
right?
Absolutely. So we've seen that so this is the thing, when people talk about misrep, sometimes, they think, oh, it's these people who are, scheming the system, right? And not to say that also does happen, but a lot of times the consults that we are receiving is for people who are very genuinely concerned and where they did not think they were, providing wrong information. But something as simple as ticking off in a visa form, one of the questions that they always ask is, have you in the past applied to enter to Canada or any other country and been refused? And if you say no, it's just a yes or no. If you tick no to that answer, and then they cross-reference with the countries that they share information with, like the U.S., and then in fact, U.S. says, oh yes, this person 2 years ago tried to apply for a study permit or a visitor visa or whatever. Now, they're not treating that as just a simple mistake. They're treating that as misrepresentation. Why? Because that answer, what it shows to an officer is that you have provided intentionally wrong information in order to get a benefit, which is in order to enter Canada. So that's the way that it's perceived. And that's why it's really important. Even when we do our work, I really take a lot of time to even those yes and no's to kind of recheck and ask people if they say no. Are you sure you have not applied to the US? Are you sure you have not applied for a visa for this other country? Yeah. Because sometimes even in the course of asking those questions, someone will say, oh, actually 10 years ago, I applied to the US and I totally forgot about it because I wasn't allowed to go, right? So there's no memories of going to the US. But it still needs to be in the application.
Yeah, another common information input, including those siblings, half siblings and the step siblings.
Yes,
that's when people are confused about it. Like my parents has 2 or 3 marriages. I never met my siblings, and they just don't feel comfortable to put them on, but later on these are the things that come back to against you, right?
Absolutely. And that could be a misrep if you don't say, even if you have no relationship, you don't even know the date of birth of this person, you never even talk to them, but you still have to put their info. So something as simple as putting their name, even if you don't know their full date of birth, you think you know the year, you could put the year and then in an explanation say that I don't know that information, but I'm giving you as much information as I have. I think that's really important.
Yeah. And I think the main issue for misrepresentation is material, right? Like the documents you put in.
Absolutely. Absolutely. And so even sometimes, so I had a consult recently where, everything was legit, but the client, because they wanted the file to look beautiful and perfect, what they did was they had taken an online bank statement and basically cropped some top part of it. And I'm not sure why they even did that, but they did, and they had submitted their application on their own. And this became a point of, like, the officer, I guess, noticed that this doesn't look like what they're used to seeing. And so they flagged it as like somebody has tampered with this, even though the numbers were not changed. But this came back as a misrepresentation on something as simple as formatting and editing a document, even though the numbers were all, fine and nothing had been moved around. So it's really, really important. I think the point of some of this conversation is to say that if you are thinking about coming to Canada in any capacity, whether it's temporary or permanent, that you take the application process very seriously, and that you really do think that, whether it makes sense to do it on my own or give it to somebody who just says they can do it, or I think make that a more prudent decision of hiring someone that this is their career, this is what they do, and this is what they see every day. They know what to look out for, right? And I think Demi and I can both agree that it's so important to work with a qualified, experienced person.
Experience is key. Yeah.
Yes, yeah.
And also, like, I think misrepresentation's consequence that we want to bring your attention is
Yes.
The 5 years bar, and then also usually after the procedure fairness letter, sometimes you get the decision right away, and then if
Yes.
it's a decision negative, and then you have the right of challenge it,
Yes.
it's a short period of time. But in most of the cases, the officer, once they receive the procedure fairness letter's response, they have to go higher ranking of the officer, which your case will be in the queue for another month or years.
Yes.
And then that's also, it's Canadian speed, but it's also going to give you a shock if you heard it, after a few months or a couple of years, and then that was the decision, and then your life have to goes on from that time for the final decision, right?
Yes.
So
Yes.
it's start from your initial application until you get the negative final decision could be already a couple of years, and then you have to wait another 5 years. And then the rumor says how serious government wants to punish these type of applicants.
Yes.
Their intent to increase that 5 years to 10 years.
Wow. Wow.
Well,
And that's huge, right? That's huge. And also, I think another thing that we kind of touched on is the fact that if someone gets this 5-year ban and they don't challenge it, or they do challenge it and they're unsuccessful, the thing is, even if that 5-year passes and then you try to reapply again to Canada or another similar country, unfortunately, that still kind of lingers. And a lot of times that will be considered in a next application. So not to overly scare people in that scenario, but unfortunately, that is a reality. And I did see a similar situation like that, where someone had done misrepresentation in a refugee file years ago, left Canada, went on with their life, and then were going to get married, and they did. And there was a spousal sponsorship that was put in. And then in that scenario, what happened was when they went for the interview for the spousal, and the spousal was legit, and they were together in a long-term relationship for like a period of time, and then they were married and all of that. But even in that interview, years later, the officer said, if you were lying in that scenario, how do I know that you're not lying now? And gave them a very, very hard time.
Yeah.
So these are just things to keep in mind, that misrepresentation, whether intentional or otherwise, is never the right way to go, right? Is never, the consequences are so heavy that, you put forward your profile. If it's accepted, that's great. And there's ways to also reapply, make it stronger. And that's also where we come in as well. But, sometimes an application will not be approved because the person doesn't have, for example, the financial ability or whatever the case is. And people have to accept that. And I tell people that's, even though we all want an approval, that's not the worst case scenario. The worst case scenario is a finding of misrepresentation, I think.
Yeah. I think today's message, and we want to pass it around to you, is before you go too further for the negative decision, I have to go to the federal courts.
Yes.
There's one thing called procedural fairness letter before, when that's happened, when an officer has adults and then they want to give you a chance to explain before they made the final decision. And that's the time you'll come to us, right? And then that's the time is the best time to fix the error.
Try to fix the error, definitely. The procedural fairness is really important. And the reason why that's a really, really important juncture to come to a professional to try to see if you can rectify is when we go to the federal court, let's just say in an instance where they don't agree with you and they do give that misrepresentation finding, at the federal court level, we have to show what was in the file. So when they give you this procedural fairness letter, that's the time to try to satisfy an officer with all your arguments and documents and whatever you need to provide that, in fact, you were not misrepresenting or there was some misunderstanding or error or something like that. So I can, as a lawyer who goes to the federal court, I can really work with what you provided in that application and what was your response to the procedural fairness letter. So this is actually a really important point that you brought up, Demi, is that if there is this finding of this misrep and they give you the procedural fairness, you need to really take it seriously and work with a professional to try to rectify that if possible.
Yeah. Another point I think I want to let you know is usually these procedural fairness letter, they give only very short period of time to respond. For example, 7 days, 2 weeks.
Yes.
But, if you spend the time retain us, then we will have the right to ask for extension because you're seeking for professional help.
Yes.
And another good reason to ask for extension, it would be, you take it very seriously and you want to make the response or submission more comprehensive. So you take time to gathering all these documents, then which it's important to get extension from our perspective.
Absolutely. Thank you so much, Demi. I don't know if there's anything else you want to add, but it's been a great chat with you about some very serious topics. And I thank you so much for being here today.
Okay, my pleasure. There will be, if you have any interest of what subject you want to discuss in the future, you can leave us a message, and then if I be able to come back, and then we can discuss it further.
Of course. We always have so much to talk about, right, Demi?
Yes. Yes.
Thank you so much, everyone. Thank you for tuning in. Leave us a comment about, as Demi said, other topics that you would like us to talk about. Thank you so much. Bye-bye.
Bye.